Professor Vesilind earned her BA degree from Guilford College, her JD degree from this lovely institution, and her LLM from the Food and Agriculture Law from the University of Arkansas School of Law. This is her 5th year at the VLS summer session. She teaches Law of Animals and Agriculture. She'll be presenting the wonderfully titled Moving Beyond the Presidential Turkey Pardon. And I guess we're going to start questions probably 1:45-ish, if we could. Is that good? Yeah. So without further ado, it's my great privilege to introduce my colleague.
Thank you, Lori. Thank you. It's so good to be here. I want to keep this informal, if that's okay with you. I do teach a very accelerated course in the Law of Animals and Agriculture. It's a 3-credit course. We power through it in 2 weeks, and then they have another week and a half to do some thinking and research and writing. It is my absolute favorite class to teach because this area of the law is just literally day to day, something changes. It's fun to keep up with, and it's fun to see incremental changes occurring in our food system, not just from an animal agriculture or animal welfare perspective, but also environmentally and food safety, et cetera. But we are in even more chaotic times right now in terms of federal regulations and federal oversight. And so I actually, full disclosure, proposed this topic a number of months ago when I knew we were going to have a new president. And actually, I think that we already did have a new administration. And I was already sort of mentally, I had in mind some ideas of what I thought the predictions were for federal oversight of farmed animal welfare, what the future was. And I will say that my predictions have sort of changed a little bit from time to time. There have been a few turns taken, and ultimately where I've arrived is that it's not going to be quite as bad as I thought it was going to be. And perhaps that is the conclusion of advocates in other areas of the law as well. Let's hope that that's right. But using the last 130 odd days as bellwether, you did catch that, as a bellwether, I see 4 general areas in which that will affect or impact the conditions for animals raised in industrial agriculture, which just to be clear for those of you who aren't working or studying in food law, is about 99% of the animals that we raise for food in this country. And so we're talking about 9 to 9.5 billion animals raised and slaughtered each year in this country. So I'm 1 through 3 here. I'll add my 4th. Before I mislead you with the impression that the last 8 years during the Obama administration was super for farmed animals, I want to dispel you of that notion. In fact, if as much as I applaud some of the progress made during the Obama administration, when it came to the regulation of animal agriculture, and particularly when it comes to the conditions under which the animals were confined or transported or slaughtered, et cetera, I would say that we were essentially in a status quo, sort of frozen. I would characterize President Obama's attitude as ambivalent in that area, but not so with his Secretary of Agriculture. Secretary Vilsack under President Obama was not particularly interested in thwarting the interests of industrial agriculture titans like Tyson and Smithfield and Cargill. And so there really wasn't very much at all that occurred at the federal level in terms of conditions for animals in agriculture or regulating those conditions. I will say though that there was progress made mostly at the state level and in the marketplace itself. And we can talk about that later if you're interested. There were a few regulatory reforms, as I'm sure you, those of you in environmental law saw, there was kind of this flurry of regulatory activity at the very end of the administration in late December and early January. And the same happened. There were a few regulations promulgated and one or two draft rules published at the very end of Obama's last term. And those I'm going to address here in terms of the fact that they've been rolled back. But I want to first discuss the transparency issues. So the USDA, of all the federal agencies, the USDA has by far the most expansive authority to mitigate unnecessary suffering of animals in agriculture. The FDA is a distant second, and for specific reasons, but mostly it's down to the USDA. We know that President Trump nominated Sonny Perdue, former Georgia governor and no apparent relation to Perdue Chicken, as the last of his cabinet appointments, and that Governor Perdue was not confirmed until almost at the 100-day mark. So almost 3 months, well, about 3 months had passed before the secretary actually assumed his role. We shouldn't interpret that as an indication of indecision or a lack of focus about USDA policy, because the person that President Trump appointed to be to run the task force, or the transition team rather, Brian Klippenstein or Steen, and I apologize if I've mispronounced the name one time, and the other time I got it right. He actually was appointed to run the transition team for the agency, and he hit the ground running. Actually, even before the administration actually came to office. Under Mr. Klippenstein or Steen's, not necessarily formalized leadership, but guidance, the agency quickly reformed or reformulated and repackaged its general stance towards animal welfare. The first, and that brings us to the first of the four issues that I think will be raised time and again over the next how many years that President Trump's in office or that his administration is running, and that is transparency. So you may recall that the Friday before Super Bowl Sunday, so here we are in the first weekend of February, there were articles that came out on about that Friday or Saturday saying, thousands of pages from the USDA APHIS website have just disappeared. Years worth of data, licensing information, inspection reports, enforcement correspondence, things like that, just were removed from the Animal Plant Health Inspection Service site, a part of the USDA website. APHIS is the division within USDA that is, among other things, tasked with enforcing the Animal Welfare Act and the Horse Protection Act. And the part of that enforcement and part of that oversight involves collecting a fair amount of information about the businesses that are regulated under these two laws. For the most part, and trying to put it into a nutshell, the Animal Welfare Act is a broad federal law that mostly sets basic, minimal standards of care for animals that are used in some type of interstate commerce. So we're talking about animals that are used in exhibitions or zoos or dog breeding or other retail animal breeding facilities of a certain size, they would be regulated by the Animal Welfare Act. Research institution, education, in education, or some, entertainment, anything, where there's some sort of interstate component in commerce or interstate commercial component in the activity and the use of animals is going to at least potentially fall under the regulation of the Animal Welfare Act. There are major exceptions to that, one of which is farmed animals. When it came to specifically research institutions, there are additional regulations that require several record keeping and the collection of kind of a diary, if you will, of considerations and decisions made by the research institution or by the entity that's conducting whatever experiments with or whatever with animals. They have to follow certain procedural guidelines, and all of that is part of the information that's potentially added to the APHIS website and was published until the early February, when it just disappeared. All this information disappeared. This was really important information for animal advocates and also other organizations who wanted to see, for example, which major dog breeders, what their record was in terms of like inspection. Had they been cited for some type of violation of housing, or did the animals appear to be neglected, or what have you? So all of that was the Animal Welfare Act information. The Horse Protection Act is really in much narrower scope, applies mostly to horses that are used in exhibition and racing. And so as you can imagine, if owners of walking horses, say, were cited for violating the Horse Protection Act, a lot of that information would then be publicly available on the website. There was a lot of embarrassment. And so it's possible that was one of the triggering events that led to the removal of the data from the USDA website. But long story short, although it's probably too late for that, it was abrupt, it was done without notice, and it was not really justified in a way that made a lot of sense to, well, me or to most of the public or people that I knew who were interested in this information. The general justification that was provided was that the agency was reinvestigating what it published on its site because it was interested in protecting individual privacy, in other words, it was considering individual privacy concerns perhaps even as weightier than the public concerns or public interests. Though animal advocates and consumer advocates considered it really a capitulation to animal abusers, because it was the animal abusers who were the ones who were shamed. It was essentially a shaming vehicle. But like I said, the Animal Welfare Act doesn't apply to farmed animals, so that's not what that information, that didn't, that kind of transparency decision hasn't impacted what we know about USDA and farmed animals. However, it does have implications under another USDA law. A different division of USDA, the Food Safety Inspection Service, or FSIS, is exactly what it sounds like. It's tasked with inspection of meat, poultry, shelled eggs, animal-based foods that are, where the animals are slaughtered, where the meat is processed, and then from there on, how it's packaged, how it's labeled, how it's transported. A lot of that is covered under law that is then enforced by and the regulations are promulgated under by the FSIS. Now, that brings us to the sole federal law that applies to farmed animals. We only really have one that has any consequence, and that is the Humane Methods of Slaughter Act. And this is a law that applies only to livestock animals, so we're talking about cattle and pigs, goats, sheep, the four-legged animals, if that's your shortcut. And the Humane Methods of Slaughter Act actually has been around for quite some time, enacted in 1958. It generally says that for livestock animals, they must be rendered insensible, or let's say unconscious, before they are actually slaughtered. Secondly, it also says that these livestock animals, when they arrive for processing and slaughter, they have to be treated humanely. So, FSIS, they are staffed with inspectors that must be on site at the meat processing plant in order for the meat processing plant to operate. These are federal employees, they're USDA employees. They are extremely important to meat production, and so they are supposed to not necessarily enforce, but at least to search for compliance with, if there's a distinction to be made there, with both the Federal Meat Inspection Act and then the Humane Methods of Slaughter Act. This is a very long way of saying there's more data being generated by FSIS. When, say, a Cargill hog plant is violating the Humane Methods of Slaughter Act because it's improperly stunning the hogs before it slaughters them, this is a violation of HMSA. And that's what the FSIS inspectors are supposed to record, and they're supposed to follow certain procedures to help bring the company back into compliance. All of that data then is posted to an enforcement website at USDA. And this is not just an animal welfare concern, but a food safety concern and consumer safety, labor safety. There are a number of different points of view and advocates that are interested in this information. We should expect that to be threatened under this new USDA approach to transparency. And I would say it's actually also probably going to be an FDA issue too when it comes to commercial uses of animals. So I think that, you know, I'm pretty sure there are people working furiously to at least document what's on there today. But I think that our ability to see how the USDA is enforcing regulations to protect at least that one part of animal production, that's going to be an issue moving forward. And then I will say this, that there was one regulation, the only improvement under the Humane Methods of Slaughter Act that occurred during the Obama administration was actually directly related to, perhaps for those of you living in Vermont and those of you who were here in about, I want to say 08 maybe, was the Bushway Slaughterhouse, veal slaughterhouse up in the Northeast Kingdom, I think it was. There were repeated violations of the Humane Methods of Slaughter Act in that young calves were treated in a way that was undoubtedly a violation of even the most minimal cruelty standards. And so that was a real black eye to the Vermont agriculture industry, and led to eventually the promulgation of a rule by the USDA that calves that are unable to stand up and walk on their own, and those are often referred to as non-ambulatory or downed animals, or downers even, that they may not be used in the human food supply. What does that mean? That means that if you are a company that's dealing in calves used for veal, you want to at least do your best to try and make sure that they are healthy enough to be able to walk on their own, and that if they are being abused in some way where they show signs of not being able to stand up or walk on their own, you now have lost them. You've lost that calf as a money, you know, as an economic value, or as you can no longer use that in the human food supply. Its value is no longer as high to you. So at least it encourages more humane treatment. But so that's that. Now, as far as the regulatory rollback, like I said, this is nothing new or particularly. It's certainly, we saw it a lot with, we've seen it a lot with environmental regulations, some energy regulations, and I don't know, did the Paris Accord, did he announce it? Has the reality show happened yet? Okay, so just curious to know. There were 2 new final rules and 1 proposed rule issued at the very end of Obama's term that are in serious jeopardy right now. And one of them, the most important one, I think, were amendments to the USDA's National Organics Program. So if you buy a carton of milk or some meat or anything that's animal-based and it's labeled organic, that label is regulated by the USDA. And there's a program that certifies producers to create and sell food that's going to be labeled organic. You can't do it, you can't label something organic unless it actually is certified as such. So although this program has been around since about the year 2000, even from its earliest stages, there were objections by people representing the interests not only of animals but consumers who were interested in honesty in labeling, that the organic standards themselves didn't make very many considerations for the conditions under which animals were raised. For example, laying hens for the production of eggs. The standards under organic are that the hens may not be caged, and so they can't be in, you may have heard the term battery cages, really very small restrictive cages in which still a majority of our laying hens are confined for the duration of their production period, which is 2 to 3 years tops. It gives them about this much room for their body for essentially their whole lives. And the organics program does not allow you to confine laying hens in battery cages. It requires them to be, quote, cage-free. Well, that sounds good, and there's a big push right now among retailers and producers to move away from battery cages into cage-free environments. And that's not to say that that's a bad thing, but that's not necessarily the answer, because if you take because the reality is that what we have now are facilities in which the hens are not caged, but they are still confined in much, much larger buildings at a stocking density that's so great that they still are under severe stress. There's still a great deal of cannibalism and aggression towards each other, towards themselves, inability to engage in any kind of real natural behaviors like roosting, or and in some cases, some studies have shown that hens in cage-free facilities have an even greater risk of injury than those who are not. I will say that's controversial, but that's still the claim that some people make. Because it all comes down to stocking density. How many chickens can you get in this one big warehouse? And so you've been buying organic eggs. I don't mean you personally. Well, I'm sure we've all been buying organic eggs at some one time or another thinking these were probably healthier, maybe even, dare I say, happier chickens than the ones that were in battery cages. And it's not necessarily the case. And in fact, that's pretty much the situation for organic dairy and organic chicken, that the labels and the promise of something being organic did not necessarily deliver on what turns out to have been a really common consumer impression that organic equaled humane, or at least organic equaled humaner, right? It was a little bit better, if not perfect. And the thing is that it could have been true. It might be true because, organically produced foods there's a wide spectrum of conditions for animals. And those who were delivering on the not necessarily regulated promise, but on the more humane conditions, were essentially at a competitive disadvantage because other major producers of organic goods didn't have to spend the money to raise standards. They were still labeled organic, and they could, basically ride the coattails of the misunderstanding of what organic actually delivered. I think I used a lot of words that I didn't need to explain that, but the bottom line is it was misleading, right? And so for the last 10 years or so, there's been this debate and these ongoing negotiations about what can we do to prevent this or at least try to fix this problem that where consumers are banking on something that's not necessarily true or maybe true, and eventually, finally determined that it would make some modest improvements, including stocking densities. That there has to be a certain amount of room for a laying hen, a certain amount of room for chicken raised for meat. That there had to be not just access to outdoors, but access to outdoors where it was actually outside, not just like a little deck or a slab of concrete. These were really modest improvements. But this was considered a victory nonetheless. It was finally promulgated, I want to say, I can't remember what day it was, but it was literally in the last, within the last month of President Obama's term. And we thought that was the end of it. We forgot about the Congressional Review Act, Newt Gingrich. But so, although this law was supposed to, these new regulations were supposed to take effect on March 30th, one of the first things that President Trump did was sign the executive order, as he did with many other regulations, new regulations, to delay the effective date until May 30th. That was time enough for Secretary Perdue to take office, get confirmed, take office, and delay it even further. So, even though this has been 10 years in the making, right now we're on one of the very last days of this new notice and comment period that was opened by Secretary Perdue at the very beginning of May. Gave us 30 days to submit new comments about these standards, specifically with these questions in mind. Should we go ahead and let these new organic humane regulations take effect, but they take effect in November because it's already been delayed until November? I didn't say that. Should we suspend the rule indefinitely and decide later whether to implement, modify, or withdraw the rule? 3, should we delay implementation of the rule to an even later date that will be undetermined? Or 4, should we just kill the rule altogether? So obviously the implication is it's not happening before November, right? But if it does, it's going to be a miracle. And we have until tomorrow to submit our comments on this. And you better believe that a lot of opponents of these standards have been busily submitting comments saying, I like option 4, but I'll take 3, and 2 is good too. So I urge you, if you're at all concerned about this, to take a look at this. This is really the most important. The AMS, Agricultural Marketing Service, National Organics Program, even if you just search on that in federalregister.gov, I believe, you can get to it there. Yeah. My link is wrong? Oh, I'm sorry. Bless your heart. I'm so sorry. I had 2 emails, and one said that was the wrong link, and I must have used the wrong one. So document. Like that? Perfect. Thank you. Thank you for checking that. So, okay. As a related matter, I don't know if you guys are familiar with Checkoff Programs. It's also run by the Agricultural Marketing Service. Major agricultural industries, whether it's milk or dairy or pork, beef, all of these sectors of animal agriculture have a checkoff program where major, medium to larger producers are, I don't want to say contribute, but are compelled to contribute a certain percentage of their that I think is based on their the number of animals they have, but don't quote me on that. Anyway, they contribute to a fund that is used to market the product. Right? Beef, it's what's for dinner. Pork, the other white meat. Got milk? Those are all checkoff program advertising campaigns that are sponsored by part of the USDA. So there's a proposal for an organics food checkoff program, which would, and it wouldn't actually affect many organic producers because they wouldn't actually be big enough to qualify. It would only really apply to the larger organic produce or animal products producers. But it's one of those things where I think that the humane regulations and the checkoff program kind of go hand in hand. If the humane regulations are rolled back, we should not be supporting the checkoff program because that then gives the USDA the opportunity to further reinforce or perpetuate the misunderstanding of what organic milk or organic eggs delivers in terms of how the animals are treated. Does that make sense? So that's that. There's one other regulation that, although it's not directly an animal welfare issue, it's certainly one that impacts animal welfare, and that is, I think it's 3 separate ones, but they're collectively referred to as Farmer Fair Practices under the Grain Inspection, Packers, and Stockyards Act, often called GIPSA. This regulation, again, was promulgated at the very, very end of Obama's term. It was in December, to give contract farmers or growers, those are people who are contracted to basically for a short period of time, say 6 weeks or 7 weeks, to raise animals on their own property in their own facilities, but under very, very strict contract terms that they would have with the actual producers. So let's say you are a Tyson chicken contract grower. Perhaps you were even in one time in business for yourself as a farmer. But now what you have is you've got the land and you've been able to build facilities that comply with Tyson chicken's requirements. You have a contract with them. That means that they will bring you chicks, deliver them to your farm, and the feed, and the additives and everything, and they'll tell you exactly what the specifications are for raising them. You know, this is what you'd give them. This is the temperature that your facility needs to be, and everything is determined. Right? There's really no actual. There are very few actual decisions made by the farmer themselves because they're not supposed to do anything outside the scope of what their contract requires. And so they will keep the chickens for the 6 or 7 weeks it takes to grow them, and then Tyson will come back and pick up the chickens and leave, and then they'll be weighed, and the contract farmer will collect their share of the will collect their payment based on a very complicated, almost kind of lottery system of pricing that really puts these contract farmers at a real disadvantage. Bottom line is, this is a crappy job, and these are the people that actually spend the most time with the animals themselves. It's a very clever system, the way that the ones who, the people who actually come into contact with animals in industrial agriculture, at least in this model, are the ones who have very little decision in how they're treated. They also don't have much in the way of bargaining or authority to, or I should say, the ability to challenge the way that they are paid. But under GIPSA and this new rule that was issued, they were given more leverage to sue the producers for unfair or retaliatory actions, which happened quite a bit. And I don't know if any of you are interested, there's a terrific book called The Meat Racket that came out a couple years ago about Tyson, although it's not just Tyson that does this. The whole contract farming model has a lot of problems that needs to be repaired, and at least of all, the contract farmers need some more, need some ability to challenge the way that their contracts are being used against them. So that, just as with the organics rule, the GIPSA Farmer Fair Practices regulation has been rolled back. We don't know yet when we're going to get to comment on whether or not it will be effective at a later date or suspended indefinitely or delayed until another date that we don't know or withdrawn completely. But my guess is it'll be withdrawn completely. So that's an issue. The second two are much shorter in terms of my explanation. As I've been talking with my class, biotechnology and the role of genetic engineering is really becoming a big issue in animal agriculture as researchers are learning how to select for traits, even, like, say, resistance to viruses, all sorts of, even the ability to create a dairy cow that emits less methane, just as a trait that is a normal function of a cow's digestive system, that emits less greenhouse gas into the atmosphere. You think this would be a good thing, but it is, of course, the result of genetic engineering, which means it needs to go through some sort of approval process. This is going to be a big bone of contention, no pun intended, sort of, over the next couple of years, because as genetic engineering practices improve and become more efficient and more rapidly developed, the agriculture industry is really going to be pushing to get the regulatory process streamlined. Right now, the way it works is kind of weird. Under the Food, Drug, and Cosmetics Act, which is under the authority of the Food and Drug Administration, right now the FDA regulates the introduction of genetically engineered animal products, of which there is now only one. And you may have heard of this, the Aqua Advantage salmon, the GE salmon. It was a big deal a couple years ago. It's approved for human consumption, but it hasn't actually been introduced yet on the market because Congress can't figure out how to label it. That said, the FDA asserts its own authority to regulate the introduction of all sorts of GE animal products or genetically engineered animals to be used for the production of food, whether it's eggs or dairy or meat products, under the idea that it is an animal drug. So it's the section of the FDCA that is the animal drug approval section. There are all sorts of reasons why that doesn't quite fit. And so it's kind of interesting. You see both the animal ag industry challenging the FDA's authority under the FDCA, saying that's not how this law works. And then you also have groups like Food and Water Watch and Center for Food Safety challenging the FDA's authority. But the bottom line is somebody's going to have to regulate this stuff. And so that's going to be an issue. Finally, this is kind of the most perhaps far-fetched, but hell, what do I know? I can't say that anything is far-fetched anymore. Massachusetts, by a ballot initiative in November, enacted a law that bans the production of veal using veal crates or calves in veal crates, the production of eggs from hens that are kept in battery cages, and the production of pork from pigs who are the progeny of sows who were confined in gestation crates, if you can get your mind around that. And then it also, as part of this law, banned the sale of all of these products in Massachusetts, irrespective of where those production practices were. So it's just like right now, California's got this law when it comes to eggs, and this was a result of a ballot initiative in 2008. Californians overwhelmingly supported this idea that it no longer wanted to support the battery cage egg production in California. So that is now, as of 2015, that's banned as a production practice. So no egg farmers in California use battery cages. But it also enacted a complementary law that bans the sale of eggs from battery cage production facilities, no matter where they're from. Whether it's from Missouri, whether the eggs are from Idaho, it doesn't matter. If they came from a hen that was in a battery cage, it can't be sold in California. And that law is in force right now. And because California gets away with a lot of stuff, it might have been okay to just let that sit for a little while, but then Massachusetts turned around and did the same thing. Now their law won't take effect until, and it's actually a more restrictive one because it's got sale bans on all 3 types of production practices. But that law will take effect in 2022. And it's got the animal ag industry understandably freaked out, because in order to comply with these kinds of regulations, not only do you have to actually really make the effort to reform certain practices, like fully phase out battery cages, for example, but it also requires a lot of record keeping and animal identification and supply chain tracking and all this stuff that doesn't happen today. And that's a lot. And so I predict that the Farm Bill is going to include at least one, if not more, of a law that attempts to preempt all state efforts to regulate agriculture. Now, there's something out there that ALEC has been supporting called Regulation Without Representation Act, which is to say, in summary, that a state may not regulate. Let's say you have a business in New Hampshire, and I'm here in Vermont, and I have a regulation that says anybody who wants to sell their product in Vermont has to comply with my regulations. Does this sound familiar? And so you, there in New Hampshire, are not going to have to comply with my regulations if you want to sell your product in my state. But you don't even have a physical presence in Vermont. You don't have a production facility. You don't have even a sales office. So how should I be able to regulate you? That's sort of the premise of the law. And that's sort of how, that way, if you have this law, this federal law that says one state cannot regulate or tax a business that doesn't have a physical presence in their state, that means that any California or Massachusetts animal production bans like we were just talking about, they aren't going to be enforceable against companies that don't have a physical presence in Massachusetts or California. We'll see how that works. There was a similarly broad preemption effort introduced in the last Farm Bill in 2013 that Steve King proposed and pushed forward. We'll see. But I think that the Congress is going to have to act to start limiting states' efforts to regulate the way animals raised for food are treated. Whether they're successful or not is, it's hard to say. But I think we'll definitely see that in the next couple of years. I went over a few minutes, too bad. But that's where I see, it's not going to be as bad as I thought. It's not great, but, it hasn't been great for ever. But it's going to, I do really believe that there are incremental changes happening. They're just not happening at the federal level. So, any questions? Mr. Chen, Professor Chen.
Hey, I just wanted to make a couple of observations for you on the last point regarding regulation without representation.
Yes,
so
please.
A couple of very quick things. The legislation appears to be an effort to codify the existing constitutional standard of Quill versus North Dakota,
Yes.
teacher of constitutional law and state and local taxation, which is why I know these things. The other
And that's written into Alex's letter.
Yes.
So go ahead.
And the other observation is that everyone overlooks this, but the Privileges and Immunities Clause of Article 4 is something that, unlike the Quill Doctrine, which is based on Commerce Clause, is immune from congressional modification, is always available, and especially for business activities, because unlike almost every other field of constitutional doctrine, Privileges and Immunities treats engagement in for-profit business as a fundamental interstate right. And what P&I actually says is that citizens of one state may not be deprived of the privileges and immunities accorded to the citizens of the state making the restriction.
Right.
So for what this is worth, just want to throw that out there as something for you to consider in addition to everything else you've mentioned, that a for-profit business engaging in the sale of animal products is almost assured under Paul versus Virginia, the case that laid this out in the first place, of getting fundamental rights treatment.
Okay, but thank you very much. I appreciate that. But I just want to say, we're not talking about a ban on the sale. I'm saying that I think we're talking about restricting certain types of a product, not banning the sale altogether. And it's certainly not discriminatory in any way, because locally produced, domestically produced products will be under the same restrictions. Does it matter in this analysis whether or not the activity being regulated is one that should constitutionally fall under state regulatory authority versus federal?
Response to that. So remember that this is in Article 4, and it's independent from the Article 1, Section 8 dormant Commerce Clause and Dormant Commerce Clause principles. So even though agriculture is the original activity that got aggregated, Wickard versus Filburn, Article 1, Section 8, Clause 3, you can indeed reach under the Privileges and Immunities Clause to things that are considered truly local, including local government contracting. And that is it's the Camden. I can lay this out for you in private later on, but I do think it's worth noting for purposes of informing practicing lawyers that this is a classic trap. Now I'll give you a quick story about this.
Wait.
Classic trap of overlooking this prospect, because if you're passing legislation that is subject to privileges and immunities attack, the classic, very short version of this, the Boston law requiring local participation in government contracting, the so-called Mayor Kevin White case, was upheld by the Supreme Court on a Dormant Commerce Clause challenge. Little footnote saying, we take no view on the Privilege and Immunities Clause because the petitioners didn't raise it.
Right.
Next year, someone from Camden, New Jersey, picking up on that clue, petitioned, got reviewed, and crushed the Camden law, which is identical in structure to the Boston law requiring a local sourcing quantum. And that is sort of the most blatant case of constitutional law malpractice, because you had a winning claim that the Supreme Court noticed for you, dropping a footnote saying, nah, and inviting someone to come the next year and exposing how you'd overlook the claim. And just pointing, these are great issues, because what you're talking about winds up touching a bunch of different issues in the federal legislative and the
Absolutely.
Supreme Court litigation bars that's worth noting in a CLE context. That's all.
Oh, well, thank you. Then for those of you getting your CLE, take note. You just earned your credit. No, I don't mean to be sassy. No, but I think it's far from settled how this plays out. And that's why I think it's so exciting and terrifying and exciting. You know, you got, on one hand, it's a, states' rights. It depends on what you're really regulating. And this is, again, something that probably is worth, time afterwards, some other time. But thank you very much. Does anybody have anything else? All right, good. Thank you so much. Yes, ma'am. Gabby, go for it.
What if you would suggest one thing that folks can do to support efforts to make industrial agriculture fall on its face or be more humane? What would it be? What do you think is the most effective tactic? I hear state, but working on a state level.
I think,
Where should we focus?
well, honestly, I think your greatest power is in your purchasing power right now. This is an exercise that my class and I've been working on this week, is that trying to figure out trying to work through promotional material and advertising claims, or I should say website claims, positioning claims made by producers about the conditions and standards under which their animals are raised. It's very, very difficult to get at the truth of the matter, because positioning statements are very cleverly worded, and there's lots of references to guidances or to guidance and certification programs and the like that are generally just basically certifying the status quo, that are considered accepted agricultural practices, how it's this is appropriate because this is how it's done kind of argument. But I think that as an informed and tenacious consumer like you probably your greatest power is right now. And that's maybe not particularly satisfying, but makes a difference. So, hey, thanks, guys. I hope you enjoy this beautiful day, the first one we've had all week.